Gun owners' #1 fighter in DC, Congressman Andrew Clyde of Georgia, has sent a letter, co-signed by 5 senators and 36 House representatives, to Attorney General Pam Bondi. The letter details Congress's dissatisfaction with the Department of Justice's defense of the National Firearms Act. Specifically, DOJ's arguments against GOA in our One Big Beautiful lawsuit against the ATF and NFA. Today, we're going to take a close look at Clyde's letter and analyze what this might mean for our lawsuit, the Department of Justice, and Pam Bondi. I'm Ben, and you're watching the Minuteman Moment. As you may have heard, the Department of Justice is now opposing us in our One Big Beautiful lawsuit. Our fight against the NFA just got so much harder. Thankfully at GOA, we're no strangers to doing the work and fighting for the Second Amendment. Please consider becoming a member and helping us take down the NFA. Let's free short-barreled firearms, AOWs, and suppressors from ATF's tyrannical registration requirements. Okay, now back to the video. Representative Andrew Clyde is arguably the most pro-gun member of Congress. This year, during the fight to pass the One Big Beautiful bill, he worked tirelessly with the federal affairs team at GOA to put language into the bill that fully repealed short-barreled firearms and suppressors from the NFA. But unfortunately, thanks to an unelected bureaucrat, the Senate parliamentarian, the registration requirements were left intact while the $200 tax on these items was removed. Now, we at GOA are suing to achieve the intent of Congress, a full repeal of the registration requirements on these items from the National Firearms Act. So, as I mentioned earlier, Representative Andrew Clyde is sending a letter to the Department of Justice. More specifically, Representative Clyde is sending a letter addressed to Pam Bondi, the Trump administration's Attorney General. In this letter, Representative Clyde goes over his and his colleagues' dissatisfaction with the recent actions of the DOJ regarding the Second Amendment. In particular, the Department of Justice's recent filing opposing GOA in our One Big Beautiful lawsuit. Here's what these pro-gun members of Congress had to say. Dear Attorney General Pam Bondi, we write to inform the Department of Justice of Congress's position and intent regarding ongoing litigation challenging the National Firearms Act registration and transfer requirements for non-taxed NFA firearms. Following the enactment of President Trump's landmark Second Amendment victory in the One Big Beautiful Bill Act. In enacting this bill into law, Congress affirmed its position that the taxation and registration provisions of the National Firearms Act are inseparably linked, and it expressed its intent to repeal the NFA's registration and transfer requirements by eliminating the associated taxes on certain firearms and silencers. In light of the department's recent filing opposing this interpretation, we must express our serious concern and disappointment that the Department of Justice has chosen to advance a theory that not only conflicts with Congress's express intent, but also disregards the constitutional structure upon which the NFA has rested since 1934. Therefore, we again urge the Department of Justice to adopt and advance Congress's stated position in all litigations concerning these provisions, to ensure that congressional intent is accurately represented and upheld before the courts. This is important. Representative Clyde is essentially telling Attorney General Bondi that Congress's intent for the One Big Beautiful Bill Act, which was also signed by President Trump, was to remove the registration requirements for short-barreled firearms and suppressors. Of course, the Department of Justice doesn't see it like that. Instead, they've defended the 1934 National Firearms Act's $0 tax as constitutional. That's like Congress abolishing the income tax, but then the IRS wanting to keep the penalty for not filing your taxes even though you don't owe any money. But back to the letter. As you are well aware, Congress enacted the National Firearms Act in 1934, imposing an excise tax of $200, equivalent to nearly $5,000 today, on the manufacture and transfer of certain firearms. The NFA also established burdensome registration requirements for gun owners seeking to transfer NFA-regulated firearms. Congress enacted the NFA pursuant to its taxing power under Article 1, Section 8 of the Constitution. The Supreme Court in Sonsinski v. United States held that the NFA's registration provisions were supportable as an aid of Congress's proper exercise of the taxing power. Furthermore, the Supreme Court in United States v. Constantine held that a tax that does not generate revenue cannot be justified as a tax. If you've watched anything about our One Big Beautiful lawsuit, this part might sound familiar, and that's because it's true. In 1937, in U.S. v. Sonsinski, the Supreme Court ruled that the NFA's registration requirements were a proper exercise of Congress's taxing power, because it was a registry of a tax payment, not a registry of a firearm. Because Congress has the power to levy taxes, the Supreme Court declared the NFA constitutional. But 2 years earlier, in U.S. v. Constantine, another Supreme Court case, SCOTUS decreed that a tax that does not generate revenue cannot be justified as a tax at all. See where we're going here? The National Firearms Act legal foundation is that it's an outgrowth of Congress's taxing power. But when a tax is removed, does the federal government still get to maintain a registry? The obvious answer is no. But the Department of Justice under Attorney General Pam Bondi disagrees. In fact, they disagree so hard that they've written extensively about it in their most recent filing in our lawsuit. We made a video about this filing recently that we'll link if you're interested. Here's the highlights. The Department of Justice called NFA items weapons of war. a talking point taken directly from the anti-gun playbook. DOJ claimed that NFA items were particularly susceptible to criminal misuse, language taken from California's anti-Second Amendment briefs. DOJ is claiming that because parts of the NFA still generate revenue, the entire thing is constitutional, including the registration of $0 tax stamps. Well, here's what Representative Clyde and other members of Congress had to say about that. The registration requirements under the NFA are, in fact, inseparably linked to its taxation provisions. Registration serves as the mechanism by which the ATF accounts for the tax paid on each firearm identified by its serial number. The tax stamp affixed by the ATF to an NFA transfer and registration application reflects both the firearm's serial number and the amount of tax paid for the transfer. Moreover, the NFA's criminal provisions pertain exclusively to the failure to pay or register the payment of this tax with the ATF. Any reinterpretation of the NFA that allows registration to persist once taxation has been removed contradicts the statute's text, its structure, and the Supreme Court precedent. Following the One Big Beautiful Bill Act's elimination of the tax on a broad class of firearms regulated under the NFA, the constitutional foundation for applying the NFA's transfer and registration requirements to those $0 tax firearms no longer exists. These requirements now operate without any corresponding exercise of Congress's taxing power, as the Supreme Court upheld the NFA's provision only as in aid of that power, and since the relevant excise taxes have been repealed, the transfer and registration requirements should likewise be understood as repealed with respect to firearms now subject to a $0 tax. The department's recent filing ignores this reality and instead offers a theory that would convert the NFA from a tax statute into a freestanding federal gun registry, an outcome Congress has never authorized and has repeatedly rejected. That's exactly right. Pam Bondi's Department of Justice is fighting to keep their gun registry, something that's actually explicitly illegal under federal law, thanks to the 1986 Firearm Owner Protection Act. But since it's a registry of a tax, the government says it's fine. Now I can already hear the moderates saying, but GOA, why wouldn't the DOJ defend the law? Isn't that their job? Isn't it unreasonable to expect them to give up without a fight? Not at all. And Congress actually agrees with us. Take this point from Clyde's letter. In fact, when Congress reduced the Obamacare penalty to $0 during President Trump's first term, the Department of Justice refused to defend the underlying flawed law. The department is fully empowered to decline to defend statutory provisions that no longer rest on a valid constitutional basis. It has exercised that authority before, and it should do so again here, this time in defense of American Second Amendment rights. Accordingly, we urge the Department of Justice to adopt the position of the drafters of this provision, that the transfer and registration requirements cannot stand without the corresponding excise tax. We further urge the department to reconsider its recent opposition brief and to ensure that future filings reflect Congress's clear directive regarding the NFA's taxation registration linkage. President Trump has already been the most pro-Second Amendment president in our nation's history, and the Department of Justice has an opportunity to uphold his strong record of protecting gun owners from burdensome regulations. Sounds pretty reasonable to us. We want to work with the Department of Justice to abolish unconstitutional gun control, not fight them tooth and nail as they defend it. At any time, they can decide if they want to be on the side of the Second Amendment. Maybe this letter from Congress will help them see that. Now, thanks for watching. Be sure to like, comment, and subscribe to stay up to date with GOA's latest fights for your rights.